One of the main differences between arbitration and litigation is that arbitrators are appointed by the parties as their judges. Therefore, party autonomy in selecting arbitrators is one of the most important advantages of arbitration over litigation. Arbitrator appointment is also one of the most important decisions for the parties, because arbitration can only be as good as its arbitrators. Furthermore, the parties' involvement in the constitution of the tribunal increases the likelihood that they will cooperate with the arbitrators during the proceedings and respect the ultimate award. This slide 5 lists the applicable provisions for this lecture, as this module is confined to 2 Arbitral instruments. So we will use the latest and current Arbitral version. Although previous lectures may have already mentioned the following points about the nature, distinction, and interaction between the model law and Arbitral rules, however, it is useful to reiterate them. Firstly, there are different versions of the model law as modified by their enacting jurisdictions. For example, the model law in Singapore differs from the model law in New Zealand. Some legislative differences may appear subtle, but are significant in practice. Secondly, representing the fundamental principles and the lowest common denominators, the model law is less comprehensive than Arbitral rules, which provides additional procedural rules and details. Thirdly, Arbitral rules are contractual in nature and subject to the legislative force of the model law as adopted by the governing jurisdiction. Finally, Arbitral rules were originally drafted for ad hoc arbitrations, but are increasingly used in institutional arbitrations, as many institutions also administer arbitrations under Arbitral rules instead of their own rules.